Good morning, everybody, and welcome to Bradley Allen Love's HR Breakfast Club for October. My name is Gabrielle Sullivan, and I'm the Legal Director here in Bradley Allen Love's Employment and Investigations team in Canberra. We run this forum monthly for our clients and affiliates, and we generally like to do it in the office to give our HR people a little bit of up-to-date information about what's happening in employment law, give you an opportunity to meet each other and kind of try and network and draw upon our collective wisdom to try and resolve some of the problems that occupy our desks on a daily basis. So we've been running this forum for, frankly, 5 years, I think, Rachel. I think we're up to 5 years. Today, I think it's our anniversary of 5 years we've been running this club. But anyway, because of COVID,
5 years today.
Here we are in virtual land, and that's good in some ways because it allows some extra people to join us. So for those of you that I've not met, who are new to Bradley Allen Love or who are dialing in for the first time, you're very welcome. It's lovely to meet you, and I look forward to meeting you in person down the track. We're going to talk about vaccinations and what else is hot in employment law today. We did send out some questions to the people that registered and said, look, do you want to put some questions in about the topics? And all we got was responses on vaccinations. So it's pretty obvious that that's what's hot. That's what we want to talk about. So the bulk of today's session is going to talk about, I shouldn't just say vaccinations, but vaccinations, COVID, and associated returning to work issues that are obviously front of mind for businesses in Canberra right now. So apologies if you dialed in for the what else is hot. There are a few other things we can talk about. We'll probably stand them over to next session and really try and drill into some of these topics along the COVID line. Probably just by way of housekeeping though, before I start, I'm not going to talk at you solely for an hour. I'm going to be, it's an exciting session today. I've got a colleague joining me to answer our questions. I'll introduce her properly about 10 minutes in. For the minute though, as I talk along, as Rachel said, please, if you would like to just ask a question, of course, we've got the chat bar there, but if you just want to jump in, jump in. If this session were in person, we're used to kind of around sort of the 40, 50 mark joining in and people just throw their 2 bits worth in. We're happy to tackle things as we go along. The object is to be useful. And of course, chat and house rules apply. So you can share your problems freely in the knowledge that the details of your queries are not going to be disclosed. Beyond that, and we ask everybody to respect that rule. So welcome aboard. Let's get into it, shall we? So what am I going to talk about? So as I said, we really want to talk about vaccinations and returning to work. The other hot issues, just FYI, there's been a fair bit of movement on casuals over 2021. We want to let you know what's happening there. Labour hire licensing is about to come live, I think 27th of November. Those laws will kick in. And for those of you in that business, you'll want to know a fair bit about that. And of course, there's been the respect at work changes in relation to sexual harassment, etc. So we were proposing to dig into those. As I say, we're going to park those. We'll probably bring them to you in next month's club. So if you need to drop out because they're the 3 topics you really want to know about, then I'll understand. But let's move on to COVID-19, vaccinations and returning to work. So what I'm going to do this morning, what's happening is there's so many questions in this area. And as I said, we've invited you to send your questions in. And by way of answering those questions meaningfully for you, I figured that the way to go about it was to give you an overview of the key sources of obligation. So the key laws or the legal framework behind those questions, so that helps us to understand and how we would work out the answer to any particular question, any particular situation. So that's complex, of course, and there's no way I'm going to do it justice this morning, but I do think you need to know, and you probably already know some of it, but I am going to whiz you through a sort of whistle-stop tour of the key sources of obligation in this space surrounding vaccinations and returning to work. Then, as I said, we're going to move to a more interactive part of the session. We're going to answer your key return to work and COVID questions based on, as I say, the input that we've got from you. Look, we got a lot of questions. They pretty much coalesced around 5 topics. So I've just listed them there. What people want to know is this: can I mandate vaccinations for my staff? What happens if they refuse? Can people work from home forever? People want to know about vaccination status and handling information around that, improving vaccination status, a range of questions around that. And lastly, protecting the unvaccinated and the vulnerable, and responsibilities in that regard. So in large part, the questions, we all write differently and we all think differently, but in large part, we're able to get those questions down to hit those sort of key topics. So what we're going to do with that, as I said, my colleague, Madeline Castles, is going to jump in, and she's done some fabulous work putting together a compendium of all the sources of obligations and applying it in some practical scenarios based on the case law. Madeline's going to come and answer your questions in that regard. Madeline, just before I go on, I'll just check that you're on board, because we got Madeline on board somewhere.
Hello.
Yeah, you're here. Terrific. Good. Sorry, my screen's a bit scant. Good. Madeline's here. Terrific. We'll click you in when she comes on board. So that's about 10 minutes time. And then we'll have a general Q&A at the end. And as I said, if you want to jump in as we go, let's do it. I will finish on time at 9 o'clock. We've all got, a lot ahead of us, of course, today. So we'll try and honour that time frame regardless of where we get up to. This session is being recorded. So if you need to leave, you can get a recording if you need to. So so we know where we're heading. Let's dive into it. What are the key sources of obligation that factor into this decision making in this regard? Well, there you've got it. I've got it for you in a slide, and it might help you all justify your confusion, or frankly, why we have specialist HR people and employment lawyers, because as we know, there's plenty of law here. If we just start, we're actually going to start on the right-hand side there. There's contractual considerations. So the contract of employment is important, and employers' implied obligations to make lawful and reasonable directions. So about, for example, being vaccinated to work. So that falls under that lawful and reasonable directions heading. So contractually, that's interesting. We're going to dive into that. There is, of course, the public health orders and the work health and safety legislation. So they're statutory obligations that, work health and safety responsibilities have always been the same, but public health orders are kind of new. And then there's the other sort of panoply of laws or sources of obligations that bear on decision-making in this regard. And they are legion, but the key sources, in my view, are as follows. There's the unfair dismissal regime, obviously, to think about, because, if push comes to shove and people need to lose their jobs, then the unfair dismissal requirements need to be complied with to the extent the scheme applies. So we have to think about unfair dismissal. Obviously, discrimination is to the fore here, disability discrimination, religious conviction discrimination, etc. And I've put there the general protections provisions of the Fair Work Act, which are effectively a secondary discrimination regime. And we've got people's rights to flexible work, request flexible work arrangements under the National Employment Standards. They've always had, right? If you're caring for a child, or you're over 55, or those type considerations, those people have always been able to ask for flexible working arrangements. Obviously, those kind of rights bear on decision-making in this regard. If your staff are covered by awards or enterprise agreements and you have provisions in there about, say, consultation, leave, flexibility, etc., well, you're going to have to comply with your own, with that award or enterprise agreement provision. We'll briefly hit on negligence and workers' comp, because those questions about, well, what about my responsibilities to the unvaccinated and the vulnerable workers, or what if one of my staff gets COVID, where does that leave us with workers' comp and negligence? So we need to touch on that. And lastly, privacy has become of paramount concern in this field, because everybody wants to know what to do with their records. Do I have to produce my COVID vaccination status? What do I do with it? How do we store it? How do we handle it? Right. So they're the sort of background provisions, and they're a lot, and they're complicated, right? So I couldn't pretend to do that justice at all. But what I do want to do, I'm going to try and do all that, unpack that slightly, one slide each, and then we're going to head over to Madeline, right? Let's just, what do I need to tell you about lawful and reasonable directions? And this is really important because at the end of the day, there's always been a deal with employees, and that is that we pay you to do what you're told, right? So there's the what we call an implied obligation to obey, and specifically what it is, it's an implied term in every contract of employment. So it exists regardless of your written document. If you have a written contract for your employment, for your employees, it doesn't have to say that. It exists, it's implied in every contract that an employee must obey the lawful and reasonable directions of their employer. And if they don't, so if an employee does not obey the lawful and reasonable directions of their employer, then the employment can be terminated if the breach is sufficiently serious. So by definition, you start, the first question, of course, you want to know, well, what's lawful and what's reasonable? And I guess thirdly, what's sufficiently serious? Madeline's going to unpack that. There's been a couple of decisions before the Fair Work Commission that I've attempted to have a little bit of a go at it, but just for your advance notice, lawful means pretty much anything that's not unlawful. Right? Got to love lawyers, right? Assaulting somebody is unlawful. So to hold somebody down to force them to be vaccinated would be unlawful, right? That's quite different to requesting that they consent to such a process as a condition of maintaining employment. So that's what lawful means. Reasonable, you'll be delighted to hear that reasonable means, well, it depends upon all the circumstances of the case. The good news is that, as I said, there's a couple of cases in there that unpack what reasonable means in the context of COVID. There is some suggestion that there's some limits. Obviously, we're moving. It's quite obvious that the whole vaccination mandate is spreading. So the limits of that have not been tested. But Madeline and I will talk that through in question time. But just park that concept in your mind for now. So that's on the contractual front. As far as the public health orders go, we're all pretty familiar with the address. But just so you know legally how it works, under the Public Health Act, the ACT government has got the powers to declare a public health emergency, which is what they've done. And that gives them the power to make orders to protect public health, including orders to mandate vaccination in certain industries. And of course, that's exactly what they've done. So you're all aware, residential aged care recently, I think because of the whole Calvary thing, it's now mandatory for workers at residential aged care facilities to be vaccinated. And I think day before, primary school teachers, right? So the source of the power for those mandatory vaccinations in certain industries comes from the public health orders, right? There are exceptions. There's this concept of a medical contraindication. And if the vaccine is not available, then those workers they're exempt from the public health order for that time. You'll want to know what a medical contraindication is, but we'll talk about that in question time because it's not what you think. It's way narrower than what you think, but that's been it's considered in some of the cases. So I'm sorry, that's not quite accurate, but we'll talk about it in question time if you don't mind. But there is an exemption there, but it's a narrow one. So that's the public health orders. And then, of course, we move to work health and safety obligations. I mean, you know, they're massive, right? The language around work health and safety hasn't changed. There's always been, as us in HR would know, that the person conducting the business or undertaking has this primary duty of care to ensure, as far as reasonably practicable, the health and safety of workers. There's also a duty to ensure that the health and safety of other persons is not put at risk from the work carried out as part of that business or undertaking. But that primary duty of care has been the same since, you know, that harmonised legislation for well, at least a decade and long before that. The key takeaway there, though, is that there's no absolute duty or absolute responsibility of employers to make sure that no harm ever comes to their employees or their workers in the course of their employment. It's to take all reasonably practicable steps to ensure health and safety. There's a difference there, and we're going to look at what reasonably practicable actually means. But before I do that, when we're talking about work health and safety, it's a good thing for employers to know that when we talk about work health and safety, we tend to think about employers' responsibilities. So the primary duty of care on employers to, it's all on you. You know, employers have to do everything. Actually, Section 28 of the Work Health and Safety Act makes it very clear that the worker also has duties under work health and safety, and they must take reasonable care for his or her own safety, and they must comply with reasonable instructions given by the employer regarding safety and cooperate with policies and procedures in that regard. So I'm just giving you a few tips for if you have difficulties in this regard. You might want to direct workers' attentions to their obligations under Section 28 of the Work Health and Safety Act. But I said I would just tell you what is reasonably practicable. What does in the work health and safety space, employers have to take all reasonably practicable steps to ensure work health and safety. Whilst the primary duty of care under WHS is fairly vague, helpfully, there is some statutory guidance to make it very clear when you're trying to work out what's reasonably practicable. We do, unsurprisingly enough, look at some obvious things like the likelihood of the hazard occurring, the degree of harm that might result, what you know about it or should know about it, and other ways to eliminate or address the risk. So employers look at all those factors, and then finally can also look at the costs associated with the ways of eliminating or minimising that risk. And if the costs are grossly disproportionate, then that's something that can be taken into consideration. So that I actually find that slide really helpful, because there's a lot of confusion in this space. But if we're talking about the COVID risk, right, and you're trying to do what's reasonably practicable to protect your staff, like I said, there's so many permutations and combinations of solutions here. But going back to what Section 18 requires, look at the likelihood of it occurring. Well, COVID's out there, right? We know that. It kind of goes up and down, but it's certainly around at the moment. And so there's always been WHS likelihood of something happening, and a focus also on the consequences. Not all risks are of equal consequence, of course, but COVID has quite serious consequences for some people, right? The degree of harm. So death is kind of right up there. So so those factors need to be taken into mind. And we all know, or reasonably know, that regardless of sort of political views on vaccinations, that the stats are pretty clear that vaccinating is an excellent way to minimise the risk of harm. It doesn't eliminate it completely, but it certainly minimises it. And I'm not making a political statement there. I think it's just a factual statement based on all the data about vaccine efficacy and whatnot that Madeline has pulled together in a fabulous compendium. But we've looked at the numbers, and they're they're incontrovertible on that score at least. So quickly just delving into, we know, so I've just talked about WHS. When you sack somebody, you have to worry about unfair dismissal laws if they earn less than the high income threshold. So you need a valid reason, and you have to follow a fair process. So the cases that we're going to discuss in a second, that they go to this whole, well, did you have a valid reason? If you wanted to sack somebody because they refused a vaccination, does that amount to a valid reason? And of course, just not forgetting that there's also process requirements. You need to tell them, give them an opportunity to respond, that sort of thing. So that sort of practical, good HR management. Don't forget that in your haste to deal with problems in the workplace arising from this. Just remember your good hygiene, as it were, in terms of unfair dismissal process. We've got these disability discrimination laws to comply with. Discrimination is complicated. But I can't really get it into a slide for you. But I suppose what I can say is this: there is the prospect in the vaccine space that people raising bona fide disability discrimination claims. So if an employer takes the position that I want all my staff to be vaccinated before they can return to work, that is a blanket rule for everybody, right? So there's no direct discrimination there. Everybody has to do this. It's not just because people with disabilities have to do it. It's for everybody. So we're not kicking into the direct disability regime, but the direct disability discrimination regime, but we may well start walking into the indirect disability discrimination scheme. And that is where a facially neutral condition, so everybody has to comply with this, has a disproportionate impact upon people with a particular attribute, such as a disability. They can't comply with that because it might affect their condition. Then there's the prospect of disability discrimination claims there. It sounds kind of worrying, but I can't do this topic justice, but there's a lot of defences or exceptions in disability discrimination law, and similarly for age discrimination, and even sex and race discrimination, really, which are the key prohibited characteristics here. Look, if the condition is imposed because it's reasonable, so let's pick the example of you must be vaccinated to be in this workplace, and then that's a defence to indirect disability discrimination. If it's an inherent requirement of the particular position, that's also a defence. And if otherwise the employer would suffer unjustifiable hardship, that's a defence as well. That's a toughie. I wouldn't be relying on that one. But the inherent requirements, if it's inherent requirement of a childcare worker's position to be vaccinated, then to the extent they wanted to bring a disability discrimination claim, then there would be a defence there. Mind you, I'm not sure that the court hasn't quite got there, but Madeline will tell us a little bit more about that one. It would have been nice if the government had come in and legislated for you all, because then you would have had a defence under statutory authority, but they haven't done that yet. They're leaving it all for us to muddle through, right? So disability discrimination's in there, but there's plenty of outs there. Religious discrimination is the other. We're hearing a bit about, well, hang on, what about my right to conscientiously object, or religious conviction? Madeline's going to talk to you about that one. I don't want to steal her thunder, but I can assure you that there are plenty of outs there. Talked about discrimination. I've talked about your other sort of your standard NES rights to request flexible working arrangements, etc. Don't forget those in the rush to sort these problems out. And finally, just on negligence and workers' comp. Well, look, all these curly questions about, well, what happens if people end up coming back to work and catch COVID because of work? Well, ultimately, in the ACT at least, illness or injury arising out of or in the course of your employment entitles you to make a workers' comp claim, right? So pretty much, and negligence, look, the take up for employers there is make sure you've got your workers' comp premium paid, and don't be reckless, right? At least follow the public health orders, and that will take you a long way to defending those claims if they have to be made. But are they going to be made? Yeah, sure they are. But okay, that's why we're insured, right? There's a bit to say on privacy, but I'll let Madeline tackle that. So it's 8:30, so I do want to stop talking a bit and try and let Madeline on. I'm just going to quickly check the chat. Right, goodo. So, Madeline, welcome. Sorry, I just can't quite see you on the thing. Are you with us?
Thank you.
Good. Well, everybody at the start, I'd just like to introduce Madeline Castles. Madeline Castles is a law clerk with Bradley Allen Love. She has degrees in art. She's in her final year at ANU. She has a fabulous history in social policy research. She was at the International Bar Association in London a couple of years ago, working on the sexual harassment in the legal profession Me Too report, which was a massive and explosive report about the prevalence of sexual harassment in the legal profession. But she's got a lot to say about a lot of things. I think you'll find her a delightful contributor. So first, I might just say, Madeline, we've got a picture of you. Can everybody see Madeline? Because I can't. Can somebody just... Yes, you can nod. Thank you. Good. Great. So you can all see Madeline. Okay. Thank you, Madeline. Sorry, my setup is, I'll just say suboptimal. Right. So based on the questions, so we've got 10 questions to whiz through, right? We'll get through as many as we can. Madeline, somebody wanted to know, they said, look, let's start at the start. According to the ACT government roadmap, what does returning to work kind of look like? Okay. So what would you say to that, Madeline?
Right. Well, Gabrielle, we were talking about this at 5 p.m. yesterday. We were bemoaning the fact that there wasn't a public health direction. You'll be pleased to know that as of 12 a.m. this morning, there is a public health direction.
And are you up to date with it, Madeline?
I am up to date with it, Gab. So there is now a public health restricted activities emergency declaration, number one, and I would recommend that everyone go and have a look at it because it has specific rules depending on what kind of business you're operating. So if you're like Bradley Allen Love and you're just operating an office, then your rules are going to be different to if you're operating, say, a function centre or a hospitality venue or something that is much more public facing. So definitely do go and have a look at that for much more specific rules and requirements for your industry. But essentially, where we're at is that employees can commence returning to work from today. And so we're at a gradual return to the workplace where it suits essentially you and your employer. And employers have obligations that they have to meet in order to enable their employees to return to work. So they have to be able to meet WHS obligations and they have to have a COVID safety plan in place. Mm-hmm. And there are also density restrictions. So I can read directly from the public health order. This is for businesses that aren't a restricted business. So there are, again, please go and look at the public health order directly to see where your business falls. But for businesses like VAL, that is just an office, your employer, you need to take reasonable steps to not allow a gathering that exceeds the sum of one person per 4 square meters. So essentially, you need to, comply with density requirements and ensure that you have proper social distancing mechanisms in place in your workplace. And you do need to ensure that your employees are wearing masks in the office. And there are some limitations to masks if people are by themselves or if they are suitably socially distanced from each other and sitting or standing at a desk. So again, have a look at those and see whether they will or won't apply in your workplace.
Right, so it's pretty similar to last year. I'm thinking about our return to lockdown from last year, except we've got masks this time, right? And we've got vaccinations. So it's but there are some specific public health directions. Sorry, we would have had those up for you today, but literally only came into law this morning. But just so going back to, so it's a public health order. So it's arising from those public health orders is where you'll find your specific answer for your specific industry or business. Righto. And like I said, anybody, if you want to jump in, jump in. So here's the question that everybody wants to know, Madeline. They said, look, we're seeing some big players mandate vaccinations for employees. We've got EY, we've got Deloitte, we've got Qantas, we've got the whole of Victoria. I mean, it's really starting to take off, isn't it? So what's the deal, Madeline? Can employers lawfully require their employees to be vaccinated against COVID-19 or not?
Well, it's the big question. I think in short, the answer is probably yes. But this will all turn on whether it is a lawful and reasonable direction. So Gabrielle's already gone through some of the sort of contracts and common law around what is a lawful and reasonable direction. But in essence, it's an implied term in every employment contract that an employee must obey the lawful and reasonable direction of their employer. So if a direction to be mandatorily vaxxed is considered to be a lawful and reasonable direction and your employee does not follow it, then that might constitute a breach of contract that is significant enough to perhaps constitute termination of employment, if that's something that you want to go down. So that raises a question: what is lawful and reasonable? So lawful is helpfully defined as anything that is not unlawful. Which is a bit circular, but essentially requiring someone to be vaccinated is not unlawful. It would be, say, unlawful to hold someone down and force the vaccination into their arm, because that would constitute an assault. But saying to, hi, Gabrielle, I'm going to ask you to go to your local vaccination centre and please consent to a vaccination is not in and of itself unlawful. So the question really then is it reasonable? And so this is when we've got a couple of cases that provide some guidance on this issue, two recent cases that were handed down by the Fair Work Commission. So one in Glover and Ozcare and the other in Barber.
I'm just going to interrupt there, Madeline. So I'm just going to interrupt just to be clear, right? So these are unfair dismissal cases, right? So that you go to the Fair Work Commission for unfair dismissal. So these are cases where the employees are being dismissed for vaccination-related reasons and they've challenged it, right? So sorry to interrupt. So we're not talking about discrimination and stuff at this point. We're just talking about people who say they've been unfairly dismissed, and this issue of lawful and reasonable directions comes to the fore. Righto, Madeline, what happened in Glover and Ozcare? Tell us about that.
So Ozcare runs aged care centres, and Glover was an employee in one of these aged care centres, and also did some home care visits to elderly patients in their care. This is all from 2020 because of the COVID pandemic. Ozcare decided to mandate flu vaccinations across their entire workforce. Glover refused to get a flu vaccination. She claimed that she had an adverse reaction when she was a child overseas for the flu vaccination, and then had been told by her parents that she should never get a flu vaccination. Glover could not get any medical evidence to assert this. She couldn't actually get a doctor to say, yes, Miss Glover has an anaphylactic reaction to the flu vaccine, she can't get it. Ozcare gave her numerous opportunities to provide this, and ultimately she didn't. And then they said, well, you haven't got a flu vaccine. And so ultimately her employment was terminated. And this is how she ended up in the Fair Work Commission, challenging this dismissal. The Fair Work Commission upheld her dismissal. They held that it was lawful. They said that it was a reasonable direction to require employees in the aged care sector to get the flu vaccine.
Yeah.
And this was because of the vulnerable nature of the clients that the aged care were dealing with, the fact that an aged care worker could become a super spreader if they were going to multiple different houses in one day, and that the employer could face liability if one of their patients, their clients, contracted flu from a worker. So in those circumstances, with the risk of spreading flu, it was a lawful and reasonable direction.
Right. So if you're in for high risk, Margot's got the hand up. She's got the hand up. Jump in, Margot. Come on.
So I just wondered, did the employer have to show any evidence that they had tried to find alternative work within the organisation for Glover before dismissing her?
So no, because flu vaccines were mandated across the entire organisation. So there wouldn't have been alternative work, I suppose. I think particularly in circumstances where this Glover's role was as a carer, to be a carer at the organisation, you had to be vaccinated. So there wasn't necessarily an alternative role that she could move to in those circumstances. And it wasn't something that was raised at the trial. She didn't raise that as that you should have moved me. It was just, no, well, I should have just been given an exemption. So, and actually that's the case in both Glover and Barber that we'll talk about next. Neither of those cases considered whether relocating or giving a different duty might have been another solution, which does, I guess, leave that question potentially open, particularly in workplaces where perhaps you might have some sections of the business that are high risk and others that are perhaps less high risk. Can you move front of house employee to back of house, for example? Those questions haven't been answered in a court or tribunal yet, unfortunately. Gab, did you have anything you wanted to add?
Oh, no, I think you've got it. And I think you've made the point already with, that the case law is really limited, right? The fact is it hasn't been tested very much at all. We've got a couple of cases in the Fair Work Commission, single instance decisions in high risk settings, so aged care, and the other case Madeline probably wants to talk about. We might just jump over it because I think the point's made. It was a childcare centre, so Barber and Good Start Early Learning was a childcare centre. So we've already got public health orders to weigh in because they're obviously high risk. So using the sort of tier system that the Fair Work Ombudsman is talking about, obviously, your frontline border workers, your tier 1, your tier 2 healthcare, sort of childcare type workers. It's pretty obvious that mandatory vaccination is going to be lawful and reasonable direction. It's when you're starting to get to, which is sort of where you're getting at, Margot, these sort of tier 3 type workplaces that frankly are places like Bradley and Love, where the tier 3 are the sort of, you've got some contact with the public and with each other, but, you're not working in a little bubble, but you're not exactly, I don't know, a dentist drilling in somebody's mouth, right? So the real issue is it going to be lawful and reasonable for businesses like ours to make those sort of directions? And as you say, Mark, I think you're right that, one of the decisions for employers, is it going to be for everybody or just for some, depending on their levels? But to the extent it's for everybody, then it's a non-issue to say, well, you can work over here. But the tier 4 people are, well, what about if you do work from home? You might have to explore the work from home option. I would have thought, how feasible is it for that particular person? Can they do their role from home? That's an interesting question. I'm just looking at time, Madeline, so I'm kind of just whizzing through a little bit. So the upshot of it was, isn't it, in those cases, Madeline, it's early days. We don't really know. Definitely in a high risk environment, it's going to be lawful and reasonable. But, it seems to me pretty clear we're getting momentum to yes. We're heading to yes, given the, frankly, not just the likelihood of the risk, but the gravity of the consequences for people. So, it's not a question that we can simply say, yes, you can do it. Obviously, it's way more clouded than that, but that's definitely where the arc of authority is heading, and it's definitely the decision-making that's being made by the key players here, and you can see that's where it's heading. So, the risk for small, for local businesses in the tier 3 level is diminishing by the minute, I would have thought, if you feel the need to do it. So I wonder if I've just cut you a little bit off there, because, Madeline, one of the issues we might just drill into, though, is this issue of medical contraindication, because it's true, isn't it, that at least for say for the public health orders, if I'm a primary school teacher and I don't want to be vaccinated, the public health order says I have to be. A medical contraindication is actually a genuine exemption to it, right? And similarly, so Ms. Glover at Ozcare, it wasn't a sort of hardened anti-vax position. She said that she had some sort of medical issue. Is that, what do you say about that in terms of, so what do we do with the few people who are going to say, I don't want to be vaccinated because I have a reaction, and here's a certificate from my pharmacist that says that. How's that going to fly? Is it going to be a lawful and reasonable direction for me to insist that they do it?
So the Australian Immunisation Handbook, which is produced by the Australian Government of Health and is sort of the benchmark on these issues, defines a medical contraindication as anaphylaxis. So
full stop.
Unless, yeah. So unless someone can prove that they have a anaphylactic response to an ingredient of the vaccine, which some people will have that, really any other medical reason for not getting vaccinated is not accepted under the handbook, and doesn't appear to be accepted by the courts as a genuine medical contraindication. It's not enough to say, maybe I developed a rash, or I felt a bit sick afterwards or something. That's not enough. It has to be a genuine, if you get this, you will have an anaphylactic reaction. And so requiring your employees to produce medical evidence to that effect would be in line with the law as it currently stands.
I was really shocked by that. Madeline said all this out in her compendium, but I was quite, okay. So I thought, any sort of medical concern means therefore you don't have to comply. Actually, no, not at all. It's really quite limited, the circumstances in which you'll meet that threshold. And then, of course, it needs to be certified. So saying you have a condition and proving it, of course, are two completely different things. But it's not improper for you as employers to be requiring that.
The other thing that I would add, Gab, is that we have a number of different COVID vaccines available, and they some of them are different to others. So while someone might be allergic to, say, the AstraZeneca vaccine for a particular reason, they might not be allergic to Pfizer, because they are actually constituted by different things. And so it's a bit different to some of the other vaccines that we have, say, the measles, mumps and rubella vaccine. That is a live vaccine. Pregnant women can't take that. Pregnant women can take Pfizer or Moderna. And so, I think that has also limited the number of circumstances where people will have a medical contraindication to vaccination.
Righto, thanks. So that's medical grounds. Tell us about one of the questions we had. Well, can employees refuse to be vaccinated on religious grounds or conscientious objection grounds? What's the story there, Madeline?
We believe the answer is no. Employees can't refuse to be vaccinated on religious grounds. None of the public health orders currently contain a religious exemption. And the government's longstanding no jab, no pay policy also doesn't contain a religious exemption. Religion is protected under the ACT's anti-discrimination legislation. So the Anti-Discrimination Act in the ACT, Section 8, provides the person will indirectly discriminate against someone else if the person imposes or proposes to impose a condition or requirement that is likely to have the effect of disadvantaging the other person because they have one or more protected attributes. And religious conviction is a protected attribute under the Act. So religious conviction is defined as having a religious conviction, belief, opinion, or affiliation and engaging in religious activity. So what does this mean? So in Australia,
help us, Madeline.
The courts have fairly narrowly interpreted religious belief, religious conviction. It's not enough to just say, I believe this because it's my religion. It really does have to be a doctrine or a tenet of the religion. So it can be a subgroup of a religion. It doesn't have to necessarily be the doctrine or tenet of the Anglican Church. It could be a doctrine or tenet of the Wesleyan Mission or the Salvation Army, something like a subgroup. But it does have to be an actual official kind of expression of the religion. It can't just be a personal belief that an individual holds. And so unless they can establish that it is either textual in biblical text, or that it's become a key tenet that is being propagated by leaders of the church or leaders of worship, then it's very unlikely to be established that an anti-vaccination stance is a religious belief.
Right. So you're going to find it pretty hard to get to meet the threshold for what your position, that your position amounts to religious belief, is going to be really tough, right? Firstly. And secondly, am I right, Madeline, that even if you could meet that high bar, provided the requirement is reasonable in all the circumstances, it's a defence discrimination claim anyway, correct?
Yes, that's correct.
Yeah. So it's going to turn on reasonableness again, and those questions, Margot, those sort of things will come into the mix there. But I think, this one, there's a lot of noise around this, but probably legally doesn't sound very far. Let's jump to return to work and work from home. Okay, so we got a lot of questions about, well, what if our people don't want to come back? Like, we're opening up, right? So, we issue our directions saying, okay, everybody, we're all heading back in a staggered sort of manner with your masks and socially distanced et al. And then people say, or some people say, oh, I don't want to come back. I want to work from home. It suits me just fine. Thanks very much. Can they do that? Can they refuse to return to work? Can they request to work from home long term? How would we unpack that?
In short, no, they can't refuse to return to work, but this is subject to discrimination law, flexible work provisions, and consultation provisions. So with a caveat that if you have contractually agreed otherwise, this also might be an issue. If you've in your contract, you may work from home indefinitely, then forcing someone to breach their contract will be an issue for you. But for most people, that's not the case. As we previously outlined, you can give a lawful and reasonable direction to an employee. So you can give a lawful and reasonable direction to an employee that they must return to the office. So this will depend on the individual circumstances of the employee. So if the particular employee has no reason other than, I just don't want to return to the office, then you're on pretty safe grounds in finding that that's a lawful and reasonable direction. And so if they refuse, the refusal is likely to be considered to be sufficiently serious and have sufficiently high consequences. And as a result, it will be a sort of a breach of contract that will be sufficiently serious enough to justify termination. So if you decide to go down that route, you need to make sure that if you decide to terminate an employee, you follow, the necessary processes. You give them an opportunity to respond, have a support person, notify them of the reason, all of those things to avoid falling foul of unfair dismissal. However, if the person has a medical reason or perhaps a disability because they don't, and that's the reason they don't want to return to work, or if they make a flexible working request because either of their disability or because they have caring responsibilities, then you might run into a little bit more trouble.
But not that much, right? Because so we're talking about the Section 65 NES request flexible working arrangement. So you might all be aware that, or frankly, at least the last decade, employees who are over 55 have to care for preschoolers, aged relatives, domestic violence, those sort of, they can make an application to an employer for flexible working arrangements, which might include working from home. But I'm right, Madeline, I know that that's effectively employers can decline on reasonable business grounds, but my recollection is that is a right without a remedy under the Fair Work Act, meaning you can't sue for breach of it. So really, the answer to this one is in large part, as long as the contract either expressly or implicitly requires that you work at the workplace, then there's nothing unlawful or improper about an employer asking them to come back and directing them if you must, and then, as you say, terminating if they refuse. We're just about out of time, so I might hit on, can we just probably tackle one more question, Madeline? We might move to records. I'm thinking about privacy and records because we did have a lot of questions about that. So some people asked, look, well, can employers ask for the vaccination status of their employees and new starters? And if we do, how do we handle the information that we get?
Yes, you can.
Yep.
You just have to make sure that you're complying with the Privacy Act and the Australian Privacy Principles, and also bear in mind in the ACT we also have the Health Records Act, which also governs this, but essentially it's very similar to your obligations under the Privacy Act. So under Privacy Principle 3, you can't collect personal information unless the individual consents to that collection and the information is reasonably necessary for one or more of the entity's functions or activities, or it is required or authorised under a law. So in this case, pretty easy to justify that particularly if you're bringing in a mandatory vaccination program. But even then, if you're concerned about work health and safety, you want to know which employees are vaccinated, which ones aren't. It's reasonably necessary to carry out your WHS obligations to collect vaccination information. So you can do so with the consent of your employees. And this also applies to prospective employees. That you're very welcome. You can. There's nothing preventing you from asking for that information. And they just have to consent.
There's really nothing exciting or novel about that, right? We've always been able to ask for reasonably necessary medical information, right? That's been long established, as I understand. So it's a bit of a non-issue there. In terms of, we might just wrap up on this, Madeline. In terms of once you do collect information about health status, including vaccination status, in terms of handling that information, we've had some people a bit anxious about, well, what do we do about that? We've got the Privacy Act at a federal level, if it applies to you, and it doesn't apply to everybody. We've got state level privacy laws as well, including the Health Records Act, as you say. Look, my take on it, I think, is that the takeaway is all you have to do is make sure, and I'm sure most reasonably prudent employers understand this, is pretty much making sure your records are accurate and up to date, making sure that reasonable security safeguards are applied to ensure that that information is not lost or mishandled or misused, and making sure you're only using that information for the purpose for which it was given, and you're not disclosing it to anybody else. I think that's a fair summary, isn't it, of the privacy principles under the Health Records Act. I think it's a massive topic, but in a nutshell, I think that's kind of it. So we can work around those. All right, folks, look, it's a couple of minutes to 9. I promised you I would finish on time. There's still a swag of questions we haven't quite answered, and if anybody's particularly interested and you want to look at the only case, is it Kimber? Is that what you're going to jump in and say, Madeline?
No, I was just going to say we had a question in the chat which was related to one of our questions. We've got a question about how mandatory vaccination orders made by, in this case, the Northern Territory, but it applies to other states and territories, how they interact with Commonwealth legislation. And so in essence, they're not, they can't be inconsistent with each other, but the states and territories have residual power to make laws related to health. It's actually really in the states and territories who do that. And as we've gone through with the ACT, all states and territories have a similar Public Health Act that allows, emergency orders and that kind of thing. In terms of Commonwealth legislation, for example, privacy that we've just talked about, if you've got a direction mandating that all aged care workers, for example, must be vaccinated, and you need to prove that, and then someone says, well, I don't want to consent to giving you my my vaccination information, that's in breach of my privacy, then that's fine. You're not breaching your obligations under the Privacy Act by asking for that information. If they don't consent, that's fine. They don't consent. You can't force them to give that information. But then they can't prove that they've complied with the public health order. And as a result, they will not be complying with the inherent requirements of their role. So, right.
Thank you, Madeline. There's a lot here, isn't there? It's not straightforward, but I have to say there is definitely a way through. It's becoming a lot easier. And employers, I don't think, should be too cowed about doing that which they see as sensible, necessary and reasonable. Perhaps we'll end there. Could I just perhaps just suggest right now, just before we hang up, if the information that we've covered very briefly today is of interest to you, as I said, Madeline has actually produced, we've been inundated with questions about this stuff. We have actually produced a relatively cohesive and comprehensive document in a compendium format that is up to date as at now, that pretty much tackles all this stuff, right? If that's something you're interested in, it is a product, as it were, for purchase. But if that's something you're interested in, I think Rachel will send you out an email, or you can let us know that you're interested if you want to have to think about that, whether that's something that's useful. But it does, you can see the nuances here. And I think while the answer is essentially yes, to get there, you do have to jump through a few hoops. And the compendium, I think, is very helpful in just reminding those of us who are in HR manager type roles that have to actually make these decisions and roll this stuff out, compliantly, there is some hoops there to jump through. So the compendium sets that out. I found it a really useful resource to keep going back to and going, oh yeah, that's right, we need to do that. So if that's something of interest to you, then get in touch with us. Or I think, Rachel, you're going to get in touch with them. Sorry, I should just check on that.
I can send an email out to all the attendees after the Breakfast Club with information.
All right, perhaps you'll do that, Rachel. Send a note out. If you're interested in that, by all means, jump on. Otherwise, as I said, this session is recorded and it'll be available on our website if you want to go back and have a look through. And I'm sorry we didn't get through everything today. But there will be another HR Breakfast Club in a month's time. As I said, we have this session once a month. Our topic, I think out of fairness to those that did want to know about what else was hot, we'll pick up where we left off for next month. So they will pick up on the labour hire casuals and the respect at work sexual harassment changes. We'll propose to cover that topic. That said, because the whole COVID issue is so important, so difficult and really big news for HR, to the extent there's developments worth covering there in the next month, we might build that as well. So you can keep your eye out for that. You're absolutely invited to join. And it's been a pleasure having you this morning. So let's get out there, Canberra, and go and enjoy our first day out of lockdown. Very nice to see you all, and I look forward to meeting you one fine day. Goodbye, everyone.
Thank you, everybody.
Thank you.